Hello, everyone. My name is Christine Mayhew. I'm an attorney in Raleigh, North Carolina with the law firm of Anderson Jones, and I practice almost exclusively employment law. And I'm honored to be here today to talk to you a little bit about unemployment benefits in North Carolina. So first and foremost, what exactly is unemployment insurance? What are unemployment benefits? So if you're a North Carolina employee and you've lost your job, you may be eligible to collect unemployment benefits under the State Unemployment Insurance Program. This program is administered by the North Carolina Department of Commerce Division of Employment Security. And I've got the email down on the left-hand side of the screen here on my PowerPoint for the Division of Employment Security. So unemployment insurance pays temporary assistance to eligible individuals who are unemployed through no fault of their own. And we will talk a little bit in a moment about what that means to be unemployed through no fault of your own. So not everyone who applies for unemployment benefits will qualify. There are certain conditions that must be met regarding initial eligibility and then remaining eligible to receive the benefits. It's important to note that it's the Department of Employment Security and not the employee's former employer who determines whether or not an employee is going to receive benefits. So in my practice, that has been a misconception that I have seen is when an employee is separated from his or her job, there's typically a question of, is my employer going to pay me unemployment? Well, it's not really within the employer's decision making as to whether or not an employee is going to qualify for benefits. That determination resides with the Department of Employment Security. So who can qualify to collect unemployment? So generally in North Carolina, there are 4 general requirements to be mindful of. First of all, again, you must be unemployed due to no fault of your own. Again, the Department of Employment Security, not the employer, makes this determination based upon information that the employee files and information that is provided by the employer. Must be considered monetarily eligible to receive unemployment. And this is a formula that the Department of Employment Security has in place in terms of earning requisite wages to establish a claim during relevant base periods. And again, that's a formula that the Department of Employment Security has in place. Must be physically able, available, and actively seeking work. So what this requirement is basically you're unemployed through no fault of your own, but yet you're ready, willing, and able to continue to work and to be employed. So someone who has decided to retire and is not actively seeking work, it's not the type of individual who is generally qualified to receive unemployment. Additionally, if you are fully disabled, unable to work, you're not physically able to work, the unemployment benefit system is not set up to compensate you. It's for individuals who, again, no fault of their own, are unemployed, but are ready, willing, and able to undertake employment. And lastly, you must register for work with the North Carolina Job Service, information that you would receive from the Department of Employment Security when you file for benefits. So we've talked a little bit about meaning an individual being unemployed through no fault of his or her own. What actually does that mean? Generally, in North Carolina, if you were fired for any reason other than misconduct, you are unemployed through no fault of your own. And the statutes set up a definition of what is misconduct. It's generally one of 2 things. And I'll go ahead and apologize up front. These definitions are full of legalese and pretty lengthy, but we'll talk specifically about how they apply in real-world situations in a moment. But just generally, as the statute set up, misconduct is willful wanton disregard of the employer's interest and deliberately violating standards of behavior that your employer has the right to expect of an employee, and or behaviors that have been explained orally in writing to an employee by the employer, or conduct which evinces carelessness and negligence of such a degree as to manifest an intentional disregard of your employer's interests. Again, definitions full of legalese, very general, very subjective. How do these really apply in the real world? So a violation of an employer's written alcohol or illegal drug policy would be considered misconduct, meaning if you were terminated from your job for violating a written alcohol or illegal drug policy, you likely would not qualify for unemployment benefits. That would be considered misconduct. You report to work impaired by alcohol or drugs, which could be the same as a violation of a written policy, or even if there's not a written policy in place, if you appear for work impaired, unable to work, probably not going to qualify for unemployment if you're fired for that purpose, for that reason. Consuming alcohol or illegal drugs on the premises. Conviction by a court for manufacturing, selling, or distributing controlled substances, if that conduct is related to work or it's in violation of an employer's work policy. Termination or suspension from employment after arrest or a conviction of just certain listed offenses, ones that involve violence, sex crimes, or illegal drugs. Again, if that offense is related to your work, or again, is a violation of employer's work policy regarding those issues. Physical violence at the workplace. So if you get into a fist fight with a coworker or a customer or even a member of the general public while you're at work and you're fired as a result, you're probably not going to qualify for unemployment. It probably would be determined that you were fired for misconduct and not eligible. Inappropriate comments or behavior towards supervisors, subordinates, coworkers, vendors, or just even to the general public related to a fairly protected characteristic that creates a hostile work environment. Again, a lot of legalese there. So what this typically means is if you have made inappropriate comments on the basis of someone's fairly protected characteristic, which is race, gender, sex, national origin, religion, disability, age, those types of things. If you have made inappropriate comments at the workplace as to those protected characteristics, likely and are fired as a result, likely are not going to qualify for unemployment benefits. Theft. If you're stealing from your employer and you're fired as a result, you're not the type of person that the unemployment benefits seek to provide for. So probably not going to be able to collect unemployment in that circumstance. Forging or falsing any document as related to employment, also considered misconduct. Violation of employee's written absentee policy. So assuming again that your employer has a reasonable absentee policy in place, if you're not showing up for work and you're fired as a result, probably not going to be able to collect unemployment benefits. Refusal to perform reasonably assigned work tasks or adequately perform your duties within a 12-month period if you have been written up 3 times during that time period for these performance issues. So a few important takeaways from those examples of misconduct. It's a fairly high level of improper behavior to disqualify you from benefits. So showing up under the influence of drugs, getting into a physical fight, stealing from your employer, fraudulently providing information in an employment application, harassing other employees on the basis of race. And those types of, it's a very high level of improper behavior to disqualify an employee from receiving benefits. Misconduct is a pretty high level, again, of misbehavior. If an employee is fired for just general performance issues, that employee may still actually qualify for unemployment, generally speaking, unless the employee has been written up for performance issues at least 3 times in the past 12 months. So again, to flip back to this prior slide, this was number 11, where you've just failed to adequately perform your job. If that happens and you're fired as a result, typically speaking, unless you've been written up 3 times within a 12-month period for performance issues, it's not going to be considered misconduct. And additionally, these issues of misconduct, they are within the employer's burden of proof in order to show. So if you are fired and seek to file for benefits, it is the employer's burden to show that you were fired for misconduct. They have to put up the evidence, they have to put up the information to the Department of Employment Security to prove that it was misconduct, the reason you were fired, in order for you to be determined ineligible for benefits. So what about if an employee is not fired, but the employee resigns? This is a question that I do see a lot. There are folks who have the misconception that if you resign, you're not going to qualify for benefits. That actually is a misconception because you can qualify for benefits even if you do resign. However, there is a different standard in play than the misconduct standard when analyzing whether an employee who resigns would be eligible for unemployment. So the standard that is in play when an employee resigns is the Department of Employment Security is going to look at whether or not that employee left work for a reason other than good cause attributable to the employer. Okay, so different standard than the misconduct. So if, in short, if an employee resigned for good cause attributable to the employer, that employee may still be eligible for benefits. So again, of course, the question becomes, what are examples of good cause attributable to the employer? And there are two, generally speaking, statutory defined reasons. Number one, reduced work hours. So if you have left employment because of a permanent reduction in your work hours at more than 50%, that may be determined to be good cause attributable to your employer, which would entitle you to unemployment benefits. Now, again, this is just a rebuttable presumption. So if your employer shows that perhaps your work hours were reduced because you weren't showing up for work, you're violating their absentee policy, you weren't doing your job and they had to assign your job to someone else and had to reduce your work hours as a result, then that is a rebuttable presumption. And if you quit and the employer puts forward that type of evidence before the Department of Employment Security, then it may be determined that you did not leave work for good cause attributable to the employer. Additionally, not only reduced work hours, but a reduced rate of pay. If it goes below, if your pay is reduced more than 15% and you then leave employment, it's presumed to be leaving for good cause attributable to the employer. Just like with reduced work hours, however, the employer may rebut this presumption and can put up evidence that perhaps the reduced rate of pay was because of low performance issues, or again not showing up for work, or other reasons, malfeasance, misfeasance, or nonfeasance on the part of the individual, and that just means perhaps misconduct on the part of the individual, and it was a disciplinary reduction in pay. Then the presumption will be rebutted, and someone who resigns for reduced rate of pay may not then qualify for unemployment. It may not be good cause attributable to the employer. So are there any other reasons other than those two statutorily defined reduced work hours and reduced pay that may qualify as good cause attributable to the employer? There are a few, but they're more difficult to establish. And for these, we're looking at case law. These aren't things that are found in the statutes, but cases that have come before the Department of Employment Security where they have found good cause attributable to the employer. Importantly, supervisor yelling at you and perhaps using obscene words in and of itself, and then an employee quitting as a result, may in and of itself not constitute good cause attributable to the employer. So I've had a lot of clients who have felt like they work in a hostile work environment, and it be characteristic of a lot of yelling or obscenities being used, and feel the need to quit. I mean, that in and of itself, believe it or not, may not constitute good cause attributable to the employer. However, if the tone of voice or the obscenities that are being used are directed at you on the basis of a protected category, such as sex, race, gender, age, national origin, religion, disability, that may be good cause attributable to the employer. If you are being harassed on those particular basis, or the obscene words that are being used against you are on the basis of those protected characteristics, that may actually then raise it to good cause attributable to the employer if you're forced to leave employment, resign as a result. Failure to pay overtime is applicable. So if you're working hours and you're not getting paid properly, and including proper overtime, and leave as a result, that could be considered good cause attributable to the employer. There is at least one case that said where there was a relocation of the workplace, which increased the employee's commute by over 50%, and the employee subsequently resigns, that was good cause attributable to the employer to entitle the resigning employee to collect unemployment benefits. In addition, as we just talked about, where the employer has the burden of proof to establish misconduct, in a situation where an employee resigns, it is the employee who has the burden of proof to show that it was for good cause attributable to the employer. So that's sort of a burden shifting as to who needs to present the evidence to convince the Department of Employment Security regarding eligibility. So how does the situation work if an employee is resigned because he or she is told you'll be fired if you do not resign, or you're given the option to resign or be fired? Typically, in those cases, the Department of Employment Security has treated that separation from employment as a termination and will generally analyze the facts from that standpoint. And again, why that is important, because it determines who has the burden of proof, who has to put up the evidence regarding eligibility. It's the employer who would have the burden in that situation, and the employer has to show misconduct. I would just advise, a practice point is in terms of if you're applying for unemployment and you have resigned because you were told you were going to be fired, or you've resigned in lieu of being fired, you should indicate that when you're filing for your benefits, so that it would be treated as a termination as opposed to a resignation. And there is a place when you're filing for benefits that you can input that information, and we'll talk a little bit more about how you file for benefits. So we've talked about misconduct, we've talked about resigning with good cause attributable to the employer. Are there any other unique circumstances that would qualify an employee for unemployment? There are a few. If you are the spouse of someone in the military and you have to leave work to accompany your spouse because they've been reassigned, that's not good cause attributable to the employer. That's not that's not leaving work for a reason other than misconduct. But it is something that may qualify you for benefits. There is a particular statutory provision that allows the military spouse relocation. A disciplinary suspension for more than 30 days. So if you have been suspended for less than 30 days and not being paid, you can't collect unemployment benefits. But if it's greater than 30 days, what the Department of Employment Security is going to look at is they're going to consider you have been discharged after that 30-day period, and then look at why you're on the suspension to determine whether or not that quote-unquote separation from employment would constitute misconduct. And if not, then you may be able to collect unemployment benefits after that 30-day mark. Domestic violence. So here is another situation I think that could be specifically applicable to clergy who are counseling parishioners on domestic abuse issues if they do have a parishioner who is suffering from that type of conduct. So in domestic violence situations, if you have an individual who reasonably believes that the continued employment would jeopardize their safety or the safety of an individual's immediate family because of domestic violence issues, and that individual then leaves employment because of that, that individual may be entitled to collect unemployment benefits. So a situation might be if, I guess, the individual who is works at the same employer as the spouse, or is being stalked at that particular place of business by a spouse who is they're in a domestic violence relationship with. Then if that individual feels like for his or her safety needs to leave employment, may be able to qualify for unemployment benefits. And the important point here is, how do you document that someone is a victim of domestic violence? So one piece of documentation that could be useful in making that eligibility determination for unemployment is documentation from a religious leader that this individual has come to this religious leader and sought assistance in dealing with this domestic violence issue. So again, this could be a situation in particular where a parishioner has sought assistance from a religious leader, and that could actually be useful in assisting this individual in applying for unemployment benefits. And there's some other reasons here too, other qualifying reasons in terms of how you establish domestic violence, and those are listed here on the slide. So having gone through what it is to be eligible and who will qualify, if you've got an employee who believes that he or she may be eligible and would like to explore filing for benefits, how does that process work? So the best way to file for benefits is to go online to the DES website, which I've again got listed here, and set up an online account and enroll for benefits online. The DES website has a great step-by-step instructions and tutorials on how to create an account and apply for benefits. And I've got both of those websites listed here. You're going to need certain information handy when you apply because the online system is going to ask you for various pieces of information, your social security number, why you're separated from employment, along with some other things. And again, a list of all of this information can be found at this website here on the slide. And I've got I'll go through it here briefly with you. You need your Social Security number, details from your most recent employer about why you're separated. Was it resignation? Were you terminated? What were the reasons behind it? And also in terms of any separation, vacation, or severance pay, because that could impact your benefits. It's a little bit beyond the scope of this presentation to talk about it, but I'll give particularly one example. So if you leave employment and you've got 2 weeks of vacation that are paid out to you, well, if they're paid in accordance with a policy that your employer has to pay vacation as part of termination of employment, that in and of itself is not going to disqualify you for 2 weeks of unemployment. However, if out of the goodness of his or her heart, your employer pays you unused vacation at the termination of employment, but there's not a policy in place that says that they will do that in every circumstance of separation of employment. For that 2-week time period that you receive those vacation payments, you're not going to be qualified for unemployment, because the way the Department of Employment Security would see that is you're continuing to get 2 more weeks of wages, and you're not, quote unquote, fully yet separated in terms of qualification for unemployment. Details regarding any retirement pay you may have. It's important here, your bank routing number and your account, if you want those payments directly deposited into your account. If you do not select direct deposit, you'll just be issued a debit card. You'll need your work history for the past 2 years as well. And so some other maybe not as prevalent issues in terms for non-citizens or former federal employees or military personnel, there's some additional information that they will need to provide when they set up an account to file for benefits. And again, all of this information can be found on the Department of Employment Security website, but I've also got that information listed here for those unique circumstances. Okay, so you've opened your account, Department of Employment Security, you've provided them Social Security number, you've provided them your bank account number, your dates of separation, reasons for separation. What happens? What happens after you've gone through that application? So after you submit your application, the DES will make a determination regarding whether or not you're eligible. As part of this process, your employer will be contacted and asked to provide information about the separation from employment, and they have 10 days to respond. Assuming there are no issues, and what I mean by no issues is the employee puts his or her dates of employment, reason for separation, and all of that matches up to what the employer has said, and it on its face appears not to be misconduct, that a person was terminated, for example. No issues, then people will receive their first payment usually within about 2 weeks after filing the claim. And this time frame can change somewhat depending on certain circumstances, but that's generally speaking. There is a 1-week waiting period before benefits kick in, and I've explained a little bit about what that means here. That doesn't mean to wait a week to file. Go ahead and file, but there will be a 1-week waiting period after you're eligible before benefits kick in. If there are issues, however, and those could be a variety of things. It could be as simple as the dates of your employment don't match up with the information that your employer provided. It could be more complicated, that you said, I resigned because I was told I was going to be fired, and the employer may come back and say, no, that's not how it happened at all. Or you could say, I was fired because I was told I violated the dress code, and the employer may come back and say, no, it actually was because you stole. There's things that could really change the determination as to whether or not you're eligible for benefits. So if there are issues, if it's a simple one, the Department of Employment Security may just notify you what those issues are, and may be able to answer some simple questions. If not, if it's a little bit more complicated, they will make an initial eligibility determination, send that to you, and if you're disqualified for benefits, then you do have appeal rights. And in fact, there's multiple levels of appeal where an employee can appeal the determination, as can the employer. So if a determination of eligibility is made and the employer finds out about it, and will find out about it, then the employer can appeal that determination as well. And again, it's outside the scope really of this presentation to talk about all the different levels of appeal and timelines and so forth, but just be aware that those procedures are in place, and there are short deadlines in place if an appeal is to be filed. So you've been found eligible. What kind of benefits are you going to receive? Currently, right now, the maximum amount of benefits is about $350 a week. for up to 12 to 20 weeks. And again, the Department of Employment Security uses a formula to determine how much you're going to receive and for how long. These amounts and timeframes can change, subject to changes in the law. The one example where there was expanded benefits that have been enacted in response to COVID-19. So you've been awarded benefits. How do you keep those going after the initial eligibility determination? Few requirements to maintain eligibility. Every week you must submit a weekly certification for which you'd like to receive benefits. And again, as you're going through the process of filing online, you're going to be given more information about how to submit this weekly certification. You must seek work with at least 3 potential employers each week and maintain a list of those, of that work search. And if you are going to work while receiving unemployment benefits, you must report the money you earn when you file that weekly certification. It is important to keep in mind you can earn up to 20% of your weekly benefit amount that you're getting from unemployment benefit without penalty. And finally, you must continue to be physically able and available to work. We talked about this at the very beginning of the presentation, but again, unemployment is for folks who, through no fault of their own, have found themselves without work, but are ready, willing, and able to get back to work. And so you must continue to be ready, willing, and able to do so. How has COVID-19 impacted unemployment benefits? And I have now crumpled this slide because I think that's kind of how we all feel about COVID-19. Just kind of want to crumple it up and throw it away. But I will say, with the onset of this pandemic, there have been some changes to the unemployment benefit system that are advantageous to employees. So I've taken this information directly from the website of the Department of Employment Security, but you can see here that you may be eligible for unemployment assistance if you have lost work for a reason attributable to COVID-19, and I've got some of those listed here. One of them that I find is very helpful is you can see you are the if you are the primary caregiver for a child in your household who is unable to attend school and you have to quit your job to stay home with him or her, you may be eligible for unemployment. And as you can see, that would not typically be a reason, for misconduct or good cause attributable to the employer, or even if some of those other additional reasons that we talked about that you may qualify for benefits. So there have been a large expansion of reasons for which you might qualify for unemployment because of COVID-19. Down here at the bottom, I will just point out, if you have the ability to telework or you are receiving paid sick leave or other benefits, you would not be eligible for unemployment as well. You can't double dip. So again, to go back to this, and this is somewhat outside the scope of this presentation, but if you're the primary caregiver for a child whose school is closed and you have to quit your job to stay home with him or her, you may actually be eligible for some new federal leave benefits that have been passed under the CARES Act, which you might be familiar with, but you can't collect under the CARES Act and unemployment at the same time. In addition, an employee who is displaced from work due to COVID-19 has some other special benefits that they're entitled to that we didn't see just under the general unemployment benefits. You should choose coronavirus as a reason for separation of employment when you set up your account with DHS and DES and provide the information regarding your separation. They have extended the amount of time a participant may be eligible for benefits, and this information can be gathered from the website. Also, there's an additional $600 a week in benefits available under certain federal programs. So again, as you may recall from earlier in the presentation, typically the maximum is $350 a week based upon a formula that the DES will put in place based upon what you were making when you were previously employed. But now there's an additional $600 a week on top of that. And in fact, if you find yourself separated from employment during this time period where these benefits are in place, even if it's for a reason not related to COVID-19, you may be eligible to get that additional $600. Also, something new we're seeing is self-employed workers and independent contractors who would not typically be eligible for unemployment can now file for benefits. And we talked about in remaining eligible for unemployment that you have this ongoing obligation to search for work, 3 jobs a week. That is being excused under this right now in terms of folks that are separated from work due to COVID-19. So I thank you for the opportunity to talk with you today about unemployment, and wish you all well. Thank you very much.